we're back with Donald Simon talking about AB 361, the Benefit Corporation legislation in California. Thanks, Donald, for talking to us again. Really appreciate it.
It's good to be here. Thanks.
I thought we could first define a few terms that social entrepreneurs may see if once the bill is passed, and then maybe you could offer some tips about what social entrepreneurs can do once the bill is passed and they're considering incorporating as a benefit corporation.
Sure.
So one of the questions that has come up is, what is a constituency statute? Mm-hmm. If you could talk a little bit about that and kind of talk about how that plays into California corporate law.
Sure.
And how that fits into this. That'd be great.
So corporate law in any state defines what the duty, the obligation is of the people that run the company. In California, the duty is defined to basically be to behave in a way that maximizes profit. Other states have what's called constituency statutes that actually authorize the company to consider other factors in their decision making beyond profit maximization. And that can include things like social and environmental and other criteria. And the Benefit Corporation bill goes beyond that by saying not only are the people who run the company allowed to consider those other factors, they actually have to consider the whole triple bottom line in their decision making. They don't have to come out any particular way at the end of the day, but they have to at least consider those things.
Okay, great. And can you talk about the third-party standard that is incorporated into AB 361?
Sure. So talk's cheap. Everybody can say that they're green, they can say they're socially responsible or care for their employees. What we've done in this bill is to require that a benefit corporation each year will go use a third-party standard to basically assess how they're doing on the full triple bottom line and then report those results out to their shareholders and put it on their website. The third-party standard, there are many of them out there that you can use to basically, it's a checklist and it says how it asks you a bunch of questions. It says, is your company doing this? How's it doing in that? It asks a myriad of different questions. What we've done in AB 361 is to say you can use any third-party standard you want, but it just has to meet these good governance criteria. And it basically requires that the third-party standard has to be comprehensive so that it considers all environmental, social, employment, and other similar factors. It has to be independent, so it can't be some rigged third-party standard that the company made up on its own. And the third-party standard itself has to be pretty open and disclose how it came up with the rankings and criteria that it selected for itself. And as long as your third-party standard that you choose meets all those criteria, you can use that. And what that does is it enables investors and consumers to really see through the marketing hype to see what a company really is doing when it comes to the triple bottom line.
Okay, great. And in order for a company to be a benefit corporation, that requires a supermajority vote of shareholders. Can you talk about that? And it's a 2/3, and can you just kind of expound on that?
So if you're going to become a benefit corporation, you need a 2/3 vote of the shareholders to become a benefit corporation. And likewise, if you're a benefit corporation and later decide you don't want to be a benefit corporation anymore, you need a 2/3 vote to go back. And anybody that is on the minority end of that decision, either to become one or to cease being one, if they don't want to keep their ownership interest in the company, then the company has to buy their shares back at fair market value. And the reason why we did that is because if a company is going to take this step, you want there to be agreement, overwhelming agreement among the shareholders of the company to say, this is what we want to be, so that the company doesn't go into this half-heartedly, and we don't want this to be some cause for disputes among the shareholders. We want it to be something where they come in unified and say, this is how we're going to make our money.
Great. It's really helpful. Now, what are some things that social entrepreneurs can do in anticipation of the bill and once it passes?
Yeah, well, that's the first thing.
If it passes, which it's going to be going to the governor on October 9th is when he has to make a decision by that time. So it's still open for support and comments.
So please do, because it's on the governor's desk. He's got until that date to sign it or to veto it. And we really need letters and calls to the governor's office as simple as saying, I support AB 361 and hope you'll sign it. Those calls and letters make a huge difference. So let's assume we get passed and the governor signs it. The law will not actually go into effect until January 1st of next year. So what you would need to do between now and then, if you wanted to jump right on it, is to really get your ducks in a row. You'd want to start chatting with your shareholders about what's involved. You'd want to chat with your corporate attorney so that they can help guide you through the statute. It's only 8 pages long. It's not terribly complicated. We purposefully wrote it to be simple, but you want to make sure that you start getting everybody in line on what needs to happen, because you need to amend your articles of incorporation to say you're a benefit corporation. You need to have a vote of the shareholders and things like that. So just to get all those things lined up and get the dialogue going among your shareholders and your attorney to get your ducks in a row, so that come January 1, you can file those papers with the Secretary of State for the state of California and become a benefit corporation.
All right, great. Some useful information, and you can read more on Innovate Social and the B Lab website. And thanks a lot, Donald. Appreciate your time.
My pleasure. Thank you.